Well, hello, everybody. It is the Christmas edition of Landlord-Tenant Zoom Radio. Glad everybody could come out during this holiday season to participate in this forum that I try to do every Saturday at 3 p.m. If you do have, if you're going to be around next week, I will be doing it for our New Year's Eve edition next Saturday at 3, so that'll be opened. We started off today with kind of a interesting song, Bruce Springsteen, that Santa Claus is coming our way. And quite frankly, ladies and gentlemen, Santa Claus is coming our way. It's almost there. We got till Monday. Obviously, our office was closed today, and we'll be closed on Monday. But of course, as we all know, the show must go on. So of course, I'm going to be doing this to the bitter end. So tell all your friends to join in, and we're able to answer your questions, give you a little bit about the law, and so that everybody is more knowledgeable. There is obviously a landmine of legislation and tricks that the politicians are forcing us to follow, and any one of these can get us into big trouble. So that's why I think these forums are invaluable, that we can get the information so that we're not involved in a lawsuit, or if we are choosing to bring forth a lawsuit like an unlawful detainer action, that we will have the best chance of winning. Before we start, I did want to talk about that, where if you got any property that's RSO, that's under the Los Angeles Rent Stabilization Ordinance, you know you're going to need to do that rent increase. It's coming February 1st. If you're going to mail it, which most people do, then you're going to need to mail it by no later than the 26th of December. I would do it right now today, send it out to take effect as of February 1st. It is a 4% rent increase. If your property is subject to statewide rent control, that is an 8.8% rent increase. Bear with me one second. Got it. Okay. So make sure that would also, again, be a 30-day notice, but again, add on another 5 days if you are going to be mailing it as opposed to directly handling it to the tenant. So I did have a couple of one more interesting thing that happened today. I always tell landlords, income property owners, when you're going to rent out a unit, when the tenant's moving in, do not make the worst rookie mistake that a landlord can make, which is that you have a personal check on a move-in. A personal check on a move-in is disastrous, because the check invariably will bounce. The guy's got possession of your unit, and on that basis, even though you think it's a crime and you're going to call the police, that's not going to happen. You're going to need to go through a standard unlawful detainer action. So I had a client call me this week, and he listened to my lectures. He followed exactly what I said, and he demanded either cash or cashier's check, and quite frankly, he got it. Unfortunately, I don't know how this happened, but the check came back. They said it was counterfeit. Can you imagine a counterfeit cashier's check? So of course, the person's in possession, won't return the phone calls. My client hasn't gotten the security, hasn't gotten the first month's rent. And I did a tweet to our wonderful district attorney, George Gascon, and said, do you think that this would be a good case for you to prosecute? And of course, I haven't heard from him, because I don't think he thinks that's a good case to prosecute. So, but that's where we're dealing with right here in the city of Los Angeles. So be very careful. Try to get that cashier's check now to clear before you give the tenant the keys. Maybe your procedures will be, well, I need to have the cashier's check 3 days before you're going to move in. And then I'll give you the keys on that time because quite frankly, my client is really going to be out a lot of money. This was not an inexpensive place. This was about $4,000 or $5,000 per month. So that's where it states. Okay, let's go over some ground rules. If you want to talk to me, great. All you got to do is electronically raise your hand. You'll see it on the bottom of your screen generally. So electronically raise your hand and I'll be happy to call on you. And then I'll ask you to unmute yourself. So if that happens, then please unmute yourself and we can start. I do like the ones where people have their cameras on, but trust me, I understand that so many people are gun shy with that. But hey, you know what? I'm showing my face, so you guys should show yours as well. So we're going to start today, and I'm going to ask, we're going to go in order here. So, and since Dina always gets in first, I'm going to ask Dina to unmute herself. Dina, are you there?
Yeah, hi, Dennis.
Hello.
Hello. I mean, again, many thanks to you. I have two questions now, but before that, are you going to continue, uploading these on YouTube or on Twitter? Because we don't see the past one.
Yeah,
I mean,
and
the last one was on the 2nd of December.
right. The problem was that, well, we were out of town 2 weeks ago, and then yesterday I had a issue with the last week I had an issue recording, so that was what it is. But this should work out fine today.
Okay. All right. And then we're going to see the last one too, right? Because I missed a big
No, the
part.
last one will not. The recording did not come out. There was a technical glitch. So,
Oh, okay.
but for
Okay.
everybody out there, if you go to my website, you will see that I'll do a little bit of video editing. I'm becoming an editor now, and I'll put it up. So go to my website and you'll see it there.
Okay, so I'll start with my questions. My tenant just left and vacated the unit last week. And because of the holidays, I'm getting very hard time of getting even contractors replying to me for estimate, but I'm working on that. And my understanding that if I get an estimate from them and the time comes for the 7th or the 6th of January to pay like whatever remainder or to present the itemization form of the security deposit, then in that case, are the estimate enough
Yeah,
to deduct money or no?
an estimate is fine. You don't
Okay.
need to have the actual completed invoice. Sometimes repairs take a long time. It's kind of tantamount to the issue that if I run into your car and you give me an estimate, but you never fix your car, are you still entitled to the money? And the answer is yes, you're still entitled to the money, whether I fix it or not. If you
Right.
cause damage to my unit, okay,
Yes.
then if I don't fix it, you still caused it and you're still responsible. Now, if you rent it out without cleaning it for the next tenant, then I don't think you can get cleaning charges. So,
Oh, so then I have to clean it before the 21st.
well, yeah, I would, well,
Send me something before 2 weeks and he didn't. So he's trying just to go wrong, right? He
yes,
doesn't.
yes, he's just trying to to gain an advantage over you. Just comply
Yeah.
with the law, send out your estimate,
Yeah.
and within the 21 days, then you're fine.
Okay.
Thank you very
Thank you
much,
so much. Thanks.
Dina. Okay, let's move on. I have next in line here, I have Kathy Yu. I'm going to ask you to unmute yourself. Kathy Yu.
Oh, hello, can you hear me?
I hear you wonderfully, darling.
Okay, thank you. I want to ask you three questions. The first one is that, I have a tenant that moved out and then it make a lot of damages and the security deposit cannot cover. And he still owe me $2,000. But that was since August, but he never paid me. So I look at the application again, he has a cosigner. Do you think I can get after the cosigner for the $2,000?
I would say so that a cosigner guarantees that not only for the rent, and again, I'd have to take a look at your contract to see the way the guarantee agreement was written. But generally it's going to cover for any damage. So I would make a demand on the guarantor, send him a copy of your security deposit itemization with all the receipts and say, you guaranteed this lease and I'm expecting you to pay it. But again, it really is dependent on the language that's in your rental agreement.
Oh, okay. The second question is that for the security deposit return, we have to return within 21 days. What happens if you are a couple days late? Can they sue you?
Absolutely. You got 21 days. It's not 22. It's not 23. It's 21. And, you know, you're a bright landlord. You own property. Get it done within the 21 days.
Okay. And then, you know, if you give a 3 days notice, if that's Monday is a holiday, you cannot give it until Wednesday, right?
You are correct. What Kathy is talking about is if rent is owed for the month of January and it's not paid, that's coming up shortly. January is a legal holiday. Therefore, the tenant has the next day, which would be Tuesday, to pay you the rent. And therefore, it would be delinquent on Wednesday. So on Wednesday, everybody dust off your 3-day notices and serve them on Wednesday. Do not do it beforehand. All right. Thank you very much, Kathy. I am going to, let's see, lower hand. Let's move over to, I have a cell phone here that ends, looks like 3932. I'm going to ask you to unmute yourself by saying *6 to the cell phone ending 3932. Hello?
Hi, Dennis.
Hi.
David, how are you?
Hello, David.
I still can't connect with Zoom, so I don't know if I don't think it's my problem. I tried 5-6 times every weekend and I can't. I don't know if other people are having the same issue.
I don't think so, because I see right now there's a bunch of people. There's 18 people in there. So
okay, it must be my computer then. Question I have is for the County of Los Angeles, what is the max that they can raise the rent, including City of Calabasas?
okay, well, if you're talking about an unincorporated area of LA County, that would be 3%. They're going to be changing it shortly, but right now it's 3%. But any other city, for example, Calabasas, which is where I am sitting right at this moment, there's no rent control in Calabasas except for statewide rent control. Statewide rent control is prevalent in every city in the state of California. So when you say Calabasas, are you talking about a single family home, a condo, or are you talking about an apartment house?
Townhouse or single family home.
Okay,
They're
so a townhouse, single family home, or condominium is not subject to any rent limitations. So you can immediately serve a notice on them and to raise their rent. If you raise it 10% or less, it's a 30-day notice. If you raise it more than 10%, then it's a 90-day notice. And again, we have that 5-day mailing rule, so make sure that you include the extra 5 days when sending that out.
Okay, thank you so much.
All right, bye-bye. Okay, we are going to move on to Audrey Smith. Audrey Smith, I'm going to ask you to unmute yourself.
Hello, how are you?
Hello, Audrey.
Yeah, my question is about the non-operative car in a carport. Once I serve a notice to perform or quit, can I put on there, fix the car and also register the car?
Well, if in fact they're violating the terms of their rental agreement by having an unregistered and inoperable car, you have the right to tell them to do two things. Either fix it by making it operable and getting it properly registered, or remove it from my property. That's what you need to tell them. And if they don't, then you have the right to proceed forward with an eviction.
Okay, and the other question is that I had a tenant to move out and then another tenant moved in who's not on the lease. So is it possible that I could just lock the door, or I have to go through that process of unlawful detainer?
There's no self-help remedies in the state of California. So if you lock that door, the police are going to be called and they're going to force you to put them back in, or they're going to arrest you. That's generally what happens in that situation. Are you sure that, first of all, have you taken rent from this stranger?
No.
Okay. So, and are you sure that your tenant is gone?
Yes.
Okay. Well, if you're sure that your tenant is gone, then we can immediately start an eviction based on the issue of an unauthorized subtenant at the end of the lease term. The lease term is over because your tenant left. That means his tenancy's done. So as long as you haven't taken any rent from this stranger, then we have the right to bring forth an eviction against the occupant. Hopefully you'll know the occupant's name, do you?
Yes.
Hold on one second. Let's see. Okay. All right. Somebody's just playing some games here, so there's always one in every crowd, right? So in any event, you can bring forth that you did you say you knew his name?
Yeah, I know her name. Well, I know the name she gave me. You know,
All right,
yes.
great. Well, that's all we care about. So what we need to do is let's go forward. You can call my office. We'll serve them with a 3-day notice to quit and bring forward with an eviction at the end of the 3rd day.
Okay, thank you.
Hey, thank you, Audrey. Appreciate it. Okay, let's move on. Get your questions ready. We'll see if we can make it through everybody. Looks like the next one in line is Hassan Uglu. How are you, sir? Unmute yourself, please.
Hello?
Hello, how are you?
Hello?
Okay, I see what this is. So we're going to mute you, my good friend, and we're also going to remove you. So have a nice day, sir. Okay, let's move on to Deborah Thompson Rosie Lee. That's a mouthful. I'm going to ask you to unmute yourself, young lady.
Hi there.
Look at you, darling.
How are you, sir?
How old are you?
I'm quite old. That's all I'm gonna say.
Well, I live with my mother-in-law, and she's right now 96, and she's great. She can walk up and down the stairs. She takes walks. She doesn't have a cane, so it's great.
Well,
So
that's amazing.
what's
I'm
that?
glad. That's amazing. I'm glad.
Yeah, she's very healthy. Anyway, Deborah, what can Dennis Block do for you? What's your question?
I just wanted to ask your advice on a little situation I'm going through right now. I recently rented a property to a young man, and in our rental agreement, he let me know that he was going to be the only person staying in that property. But a few months later, I found out that another person moved in, and that wasn't a part of our rental agreement. So what should I do in this situation?
What city, please?
Currently, I'm in Los Angeles.
Okay. Is this an apartment or a house?
This is an apartment.
Okay. So if it's an apartment, we can serve her with a 30-day notice to get rid of the strangers. At the end of the 30th day, if the strangers are still there, we have the right to evict everyone from the unit.
Okay, thank you.
All right, bye-bye. Thank you. Okay. And now we are going to move on to Mark Jefferson. Come on down by unmuting yourself, young sir.
Hallo, det var Dan. Det var där vi fick.
I'm sure you're saying something, but could you speak a little clearer?
Can I get in prison if I shoot someone?
Well, it all depends. If they're coming after you with a gun or a knife, I would think that's justified. But I don't understand what that has to do, Mark, with landlord-tenant law.
Pilot love.
Okay, Mark, you have a great day. Okay. Let's see. Okay, let's move on to, boy, they're coming out of the woodworks. You think it's because it's the holidays today, ladies and gentlemen? Maybe. Let's move on to Anton. Anton, I'm going to ask you to unmute yourself.
Hello.
Hello, Anton. Okay, Anton, I love you too. And let's just remove you. Wow, we're having fun today. All right, let's move on to Leonard S. Leonard S., I'm going to ask you to unmute yourself.
Hello, can you hear me?
I can, and I'm hoping
No,
something
this
intelligent.
Yeah, in fact, I have a few questions for you. Real estate questions, not any, and it's a shame that you're getting these jokers on there. I'm really sorry about that because all the time that you take, and I appreciate your time. My first question for you is AOA. I'm a member of AOA, and I see that AOA has a 3-day notice and you have a 3-day notice. They're completely different. I know, of course, yours would be better because you're the lawyer, but is AOA's okay to use? I mean, they have a lot more weird detailed in there. And
Okay, the notices, while they might look different, have all the required information that the law requires. And that is, you have to state the amount of rent that's due. You have to state the address where to pay and who to pay and phone numbers and times to pay. You have to have the name of the tenant. You have to state, you don't necessarily have to state the period for which it's due. That's probably what's getting you that.
Yeah, that's
You're
correct.
saying that it says each month. You don't need to do that. In fact, the law doesn't even require a period, though we like putting that in. It also has to state that that the 3-day notice excludes Saturdays, Sundays, and judicial holidays. So, but the notices are equally good. To be frank with you, I approved both of those notices, and I have added to the AOA notice as well as my own.
Okay. So that's okay. The other thing is, I noticed that on one of your items, you had one of your videos, you talked about you can actually put a rent collection box on the property, or you can put a location of a bank with the account number. Could you do both? And then if you did both, could you actually do like 2 forms? So again, I'm giving them a choice so they can say, oh, well, I didn't have a choice, or I couldn't get to the bank, but I'm giving them a choice, or you only have to put one or the other. I was going to put both somehow.
It doesn't hurt to put both, but I think it's a little bit too much information to throw into a 3-day notice. I like the rent collection box. I have that at one of my units where I don't have a resident manager, and it's just easy. But you can also give the option to a tenant to pay it to your bank. However, you have to understand that if you pay it to a bank, you have to, number one, obviously name the bank, give them your account number, not the routing number, but your account number. You have to state an address of the bank within 5 miles of your property. You also have to state the times that the bank is opened. So
Okay.
like, Monday through Friday, 9 to 5, and on Saturday, 9 to 2, for example. So that all has to be in the notice to make it a legal notice.
Okay. And then I was just wondering, it's hard to get a hold of you. I know you're busy, swamped with evictions left and right. How much do you charge for an eviction? I mean, I can't find that on your website. I tried to call.
You're right. You can't. I'll tell you how to get in touch with me, but I don't want anybody else to hear this who's in this Zoom meeting. We can't really quote prices because it all depends what kind of a case you have. So we're happy to tell you exactly what we charge. But if you call between 7 to 8 a.m. only, you can use my extension, which is 1001. That's between 7 to 8 a.m. only.
Okay.
And I will answer the phone. If you call outside of those hours and use my extension, I will slam the phone down.
Okay.
But otherwise, I talk to a bunch of people between 7 to 8, and then you have to wait till 9, go into the switchboard. So we do have a lot of calls, but I'll give you that. Anyway, thank you very much, Leonard. I am going to move on. Let's move on to Mark. Mark, I'm going to ask you to unmute yourself.
Hello.
Two, let's move on. I don't think we did this cell phone number 1476. I don't think so. So I'm going to ask that cell phone that ends 1476 to say hello. Oh, *6 if you're on a cell phone. *6 to unmute yourself. And if that is not, I'm going to ask you to unmute yourself, *6. Okay, we're having technical difficulties. I am going to move on to another cell phone, which is ending 3043. And I'm going to ask that person to unmute themselves. If it is a cell phone, *6 to unmute. Say hello.
Mr. Block
Hey there.
and this whole fam, can you hear me?
I can hear you wonderfully.
I have a question. So in an eviction case, just say we serve them a notice to quit, and then they vacate the premises. When do we have to refund the security deposit by?
Well, I think I talked to Dina about that. It's 21 days from when you got possession of the premises. 21 days, and that has to be, that form is on my website, which, by the way, is evict123.com. There's no charge for that. And just mail it to the last known address, which would be your property, unless you know where they work or you know, or they gave you a forwarding address.
Do we have to provide proof of mailing as well too, or no?
You don't need a proof of mailing. It certainly doesn't hurt, but you don't need a proof of mailing.
Okay. All right. And then in terms of like charges wise, so just say you miss the time frame, what happens then? Then you mail it on the 22nd day.
Well, then technically they could sue you for the entire security deposit back.
Even for like rent balances too?
Well, they can ask for their full security deposit back. That doesn't mean that they now don't owe you the rent. If they sue you in small claims court, I always advise my clients to file something when you get the small claims court lawsuit, go back to that same court, file something called the defendant's claim. It's kind of like a cross complaint, like you're suing me because I didn't do it within 21 days. Well, I'm suing you because you still owe me the rent. It doesn't magically disappear.
Okay. All right.
All right. Good luck,
Okay.
sir. Okay. You know, we have been ignoring Ruth and Barry Binder. I'm going to ask you to unmute yourself. Ruth and Barry.
Hi.
Hey there.
Is rent increase due February 1st? Do we send a notice now?
Absolutely, because if you're going to mail it, you got to do it 30 plus 5 days for mailing. So I would do it right now today.
Well, I can't do it today. It's a weekend. If I do it,
Well, you
if
can
I
put
do it,
something in the mail today, darling.
okay. If I do it on Monday, am I still okay? 35
Let's see.
days.
Monday is what? Monday's Christmas. I
No,
love you.
Tuesday, 26.
27, 28, 29, 30, 31. You're okay.
Okay, last question. Do I need to complete the City of LA rent registration for 2024 prior to sending the rent increase?
No, one has nothing to do with the other.
Okay, I thought I need to attach the proof of.
No, you're okay.
Okay, so as long as I make it in 2023, is email considered personal service?
Email's considered zero, nothing. Don't do it.
Oh, don't do anything. So I can just mail it. I don't have to post it, do I?
You do not have to post it. You can just mail it. We like you to post it and mail it, or hand it to the tenant is actually the best.
Got it. Okay.
All right,
Thank you.
Ruth. Nice
Thank you.
talking to you. All right, we are going to move on. It looks like here I have a Tara. Wow. I'm going to ask you to unmute yourself, please. Tara, don't disappoint me.
Oh my gosh. Hi. Can you hear
Hey.
me okay?
I
Hey
can
there.
now.
Excellent. I was the 1476 cell phone trying to get through. So
Oh,
thanks for your patience. Quick question. I'm in Burbank. I own a townhouse. We've got tenants in there now. Their lease ends in February, so February 28th. And I'm just wondering how much notice we need to give them if we want the unit vacated so that we can sell it.
Burbank doesn't have any rent control, and your townhouse is not subject to statewide rent control. Have these tenants are currently on a month-to-month tenancy?
They had extended to a year tenancy. So they finished it. They did 1 year and then they renewed for a second year.
Okay, and when is that lease up?
February 28th.
Okay, so
Yeah.
just send an informal letter now,
Okay.
which says, "Hi, your lease is up February 28th. You've been wonderful tenants, but I have other ideas for this place. I expect you to vacate." So you're not giving like a 30-day or a 60-day notice. You're just giving them an informal letter. I would just mail it by certified mail, not where they have to sign for it, so that they have as much time as possible to find another occasion. But and Burbank is threatening to install rent control, but right now you're okay. Actually, my main office is in Burbank, so we're neighbors.
Oh,
But
gotcha. Okay, thanks.
but I would just send that informal letter now, just explaining that the lease is up February 28th. It's not going to be renewed, and we expect you to vacate.
Okay, got it. Thank you.
Thank you. Okay, let's move on. Let's see here. Bear with me. Let's try this number again. Actually, let's try this one. It's a cell phone number that ends 1217. I'm going to ask you to unmute yourself by hitting *6. That generally should do it. Hello.
Hello, Mr. Block. Thank you for your time and help. My name is Giorgio, and I have 2 tenants in my building in the city of Los Angeles. Each one of them owes in a neighborhood of $20,000 back rent. Is that due on the February 1st?
Good question. I meant to talk about that, so I'm glad you raised the issue. This is in the city of Los Angeles.
Correct.
All
Worst
rent,
city possible.
all rent that became due as of October 1st, 2021 through January 31st, 2023 is due on February 1st, 2024. Let me repeat. Any rent owed from October 1st, 2021 through January 31st, 2023 is due on February 1st, 2024. If you don't have your rent on February 1st, we could actually serve a 3-day notice to pay the rent.
Okay. I feel like based on this legislation, anti-landlord legislation in the city of Los Angeles, it would cost me an enormous amount of losses, because if I was to evict both tenants, I would not be able to collect rent going forward from the time of the inception of the eviction until the resolution. Is that correct?
You are absolutely correct. However, what you can do is you could just sue them in small claims court and get a judgment against them, and you're still able to collect the rent from February forward in time next year.
The last question.
Yes.
Is it possible, I know this is a little outlandish, but is it possible for me to make an agreement with them to pay me an extra $1,000 a month on top of the regular rent that is due? And also, if they fail, they would waive their tenant rights and move out immediately on the failure of paying the.
Well, yeah, you could do an agreement like that, but what happens, my good friend, when they say, "I'm not moving," then what? Then you're facing an eviction, and you're going to need to not take any further rent during the course of the eviction, of course. So I don't think that's going to fly. I mean, you might try to make an agreement with them saying, "Hey, look, this rent's due come February 1st. Pay me X amount of dollars per month," and see if they're willing to do that. But again, if they stop paying, you're going to have to go forward with an eviction.
But if in lieu to the agreement that by paying $1,000 extra, I won't evict them now, if they agree to waive their tenant rights, can I just evict them without the right to a
You
trial
can't
or
just
whatever.
evict somebody because they sign a paper saying, I can be evicted right now. There's no way to do that. You're still gonna have to file an eviction lawsuit and go through the same procedure, my friend. So, okay, let's move on.
Please.
Thank you for
Thank
your
you.
call. All right. Okay, let's see if I can get, I see we're going around here, so that's good. Let's see if I can get this caller again, which is 3726. That cell phone ends in that. I'm gonna ask you to unmute yourself by hitting *6. Anybody there?
Hello.
Hey, we
Can you hear
got
me?
you. I can now,
All
Deb.
right, perfect. Okay, hi, this is Suzette, unincorporated county of Los Angeles.
Sorry
So
about that.
Can you hear me?
I can.
Okay, so I'm in the LA County unincorporated area. And my question is, if I'm able to serve a 3-day notice, when I'm able to serve that, the Consumer and Business Affairs requires they also receive a notification, that 3-day notice, and they told me that I have to email it. Do I have to email it, or can I mail
No,
a hard copy?
You can mail them a hard copy. You have to do it within 5 days of the service of the notice. You also have to include in it your proof of service. And we just, in our office, we don't email it. They like it emailed so that they don't have to do any work. So we mail it every time I have a proof of mailing, and we mail it into them. So, but again, it's not just mailing the 3-day notice, it's mailing the 3-day notice and the proof of service. And again, that's within
Okay.
5 days of the service of the notice.
Okay, that sounds great.
Well, thank you. Glad you could make it in.
Thank you, Paul Lakers.
Thank you. Yeah, my team's kind of in the toilet, lost 4 in a row.
I know.
They're
It's my
playing-
team too.
They're playing tonight, and of course, I'll be watching a little bit of it, but then on Christmas Day, don't call my office because me and my boys will be at the Laker game. I think the game starts at 2 o'clock, so we'll be downtown. Anyway, nice talking with you. We are going to move on. I see Tara has another question, but let's go back to Dina. Dina, love you. And what's a new question, young lady?
Hi, Dennis. Thank you so much. The question is regarding the unit that I have to put on behalf of the tenant, which starting January, if he pays me the rent, it's going to be 7 months of rent. So when I put it on the market, can I put it only for 7 rents? So still I am doing my best effort and he will be paying every month, or I can't do that? Or you want to advise me probably by putting it month to month? And if so, how can I evict them or tell them, because I want to go after that and put it at market rate, which is around like
Right.
$300
Well,
more.
is this an apartment or a house?
No, it's a condo, a single family condo.
Okay, so then what you can do is we just rent it out month to month. And this is what city, please?
Diamond Bar, which is incorporated. And
Okay.
the property is exempt.
Right. So it's an exempt from statewide rent control too. So you can just do a 7-month lease.
Okay.
And then at the end of the 7 months, you can raise it to whatever you like.
Oh, can I do that?
Well,
Or
a
it's
condo is not subject to any rent limitations, so you can always raise the rent
Right.
as much as you
But-
like.
But if I do it just month to month, when I am being able to serve him 30-day notice and say that's enough?
Again, your issue for the audience was that you want to hold your tenant who left early on your rental agreement. You want to hold him
Yes.
responsible. And
Yes.
as we've talked about in the past, you need to, if you're going to try to hold that tenant responsible, then you can't jack up the rent. You got to try to rent it for the same price.
Yes, I will.
Right.
But
So
the
if you are
timing-
renting it for the same price, then once this tenant's is in there, you can just either raise the rent to whatever you like, especially if it's on a month-to-month tenancy, or you can
Yeah.
just serve a 30-day notice to vacate.
Okay, so then that wouldn't interfere with him paying rent or something if
You
we
could-
do like But when we advertise, can we say it's for 7 months only?
Yes, of course. You can do that, or you don't have to advertise that, but you just need to, if you're gonna hold him responsible,
Yes.
then you have to rent it for the same amount of rent.
Okay,
Wait.
thank you so much.
All right, Dina, let's move on. I see a new caller here. I got Jesus. Jesus, how are you? Unmute yourself, young sir.
Oh, voll die geile Ficklatte.
No, I see.
Denn
There you go. We'll get rid of you quickly. That's nice. Okay. Hope you're having fun. Let's move on to, I see this number here. I can't see whether I've asked it before, but I'll try again. 1217 is the last four digits. I'm going to ask you to unmute, and if you could hit *6. That's for, yeah, there you go.
Yeah. Yes, Mr. Dennis. Do you have a form or anything that I can use to make a past rental due agreement, payment agreement?
There's no form. That would just be some sort of, a contract as to when these payments are going to be made. I don't have any form contracts. I don't think it's very difficult for someone to just prepare it, on some stationery or on your computer where you're going to say, this is what you owe me and this is how you're going to pay me back.
Okay, but it doesn't become a change of tenancy. It's just simply
No,
adjacent to-
it's a repayment plan is what it is.
Okay, well, thank you so much.
No problem. And let's take a look at the beautiful Tara. And now I can see you. I'm going to ask you to unmute yourself.
Hi, David. Hi again.
Hi.
Quick question, which is that I went back and took a look, and it looks like my tenants, so again, Burbank townhome, the tenancy, we are looking to sell in March, but they're actually on a month-to-month lease. So how much notice do I need to give them?
They're on a month-to-month, and
Yeah.
you want to increase the rent or you want them to go?
I want them to go so we can sell the unit vacant.
60-day notice.
60 days. Got it.
Yes.
Perfect. Thank you.
Thank you. I see that we have somebody here called Eva Braun, and based on that, let's remove that person. Pretty smart. And I'm glad you guys are having fun today. But I think I've got you beat. So let's move over to Mark. I'm going to ask Mark to unmute himself.
Hi, Dennis. Good afternoon. Thanks for taking my call. And thanks for doing this. This is very helpful. We've got some Section 8 tenants with the county housing authority. I think it's only county doing this right now, but they started a new policy where if you request a rent increase, they will actually review it. And if they plug it into their model and it comes out as the rent should be lower, in their opinion, they'll actually lower the rent instead of increase the rent. So, and they can do this without even giving you a warning or an opportunity to withdraw your rent increase request. Is that legal? And, it could take a long time to make up for a rent decrease, to get it back to where it should be. It could be 3 or 4 years. How can we, go ahead.
And it's interesting because the county and the city of Los Angeles have the new fair market value figures just came out. I believe they're on my website. And they, of course, went up. So I don't see how they could be lowering your rent. Can they lower the rent? Well, I don't know what the terms of your Section 8 contract. It sounds very odd to me. But I just don't see how they could do that. You agreed to this rent, and unless there's something in a Section 8 contract that says that they determine any rent increases or any rent decreases, if it doesn't say decreases, I don't see how they can do it. But nothing surprises me at this time. Nothing.
Thank you.
All right, Mark. Appreciate you. Me and Mark go back a long way, so always nice talking to you. Let's take a look. Let's go back to Leonard S. Leonard S. has another question. I'm going to ask you to unmute yourself.
Yes. Hey, thank you again. Sorry, I had a few questions. Are you allowed to sue someone in small claims now, being that you know where they live, as opposed to waiting for them to vacate and leave and then trying to hunt them down for like possibly about the $8,000 that they owe? Is it better
Well,
to?
if the money is due now, you can always sue them while they're in possession of your unit. That one has nothing to do with the other.
Okay, so then I could get a small claims, have them served now.
You got it.
Okay, and then one other thing, about what are the differences between a 3-day notice in a rent controlled building and a non-rent controlled building? Because I have a tenant in each building, and I know in the rent control, you have to fill out your form, for example, hand it to them, post it or whatever, and mail it. And then you have to also fill out the form for the city and submit that. So is everything the same, but submitting the one into the city, which I don't have to do because it's a non-rent control building?
Right. I mean, the 3-day notice is the 3-day notice. And so
Okay.
that's the same. But some municipalities require that you mail a copy of the notice to them. Like, for example, the city of West Hollywood. Some municipalities request that you not only mail it to them, that you have to mail it to them with a proof of service. Some municipalities, for example, if you're talking about a 3-day notice to perform or quit, unincorporated areas of the county require a 10-day notice. It's just a landmine of knowing these facts. I have the chart on my website. If you go to the free forms area, and it'll say notice requirements for different municipalities. Check that out. Your head will swim, but it does give the addresses and what's required in each of those jurisdictions.
Well, I'm definitely in the city of Los Angeles, but one's under rent control, one's not. I'm just wondering, do I have to submit?
Both have to go to the city of Los Angeles. It has nothing to do whether it's under rent control or not. You've got to send a copy of the notice and their eviction cover sheet to the city.
Okay. I didn't know that you had to do that for a non-rent controlled building. Okay, got it.
All right, let's move on. I see a phone number here, 3726. That's what it ends. Please hit *6 to unmute yourself. 3726.
Sorry, I forgot to put my hand down. How do I do that?
Oh, I'll take care of that for you, sweetheart. Okay,
Yeah, we already spoke.
Okay, darling. Okay, I'm going to mute you then. Then we're going to go to, I see this phone number again, 1217 it ends in. And I'm going to ask you to unmute yourself by hitting *6 if you want to have another question. And maybe not, *6, because your hand is up. Are you there?
No, I forgot to unmute.
Okay, no problem, sir. I will mute you. So it looks like I think we're out of questions today at the time. I do want to wish everybody a happy holiday and a prosperous new year. We just have to stay vigilant with regard to the laws that are coming at us. We know that in July of 2024, they're going to limit our right to get a security deposit of 2 months rent. It's only going to be 1 month's rent unless you have a total of 4 units in a combination of 2 buildings. But other than that, if you have an 8-unit building, your new tenants coming in are going to be required to only pay 1 month's security deposit. I think, as I said in a previous telecast, that you're going to need to raise your criteria, because a great way of preventing bad people from coming into your unit is asking for 2 months rent. If they have that wherewithal, then they're at least a little bit more down the road to being a good credit risk. But again, I would expect everybody to really do your credit checks, check everything out, check social media. I would go to the county court website and see if this tenant has been, or applicant has been, the subject of some lawsuits. You can check, you can do a plaintiff defendant index or a defendant index. And in that situation, if you see that your tenant has filed 29 lawsuits in the last 5 years, guess what? You'll be the 30th lawsuit. So these would be legitimate reasons why you wouldn't want to talk or take this type of an applicant. And again, we, as of July 1st, their wonderful state in their ultimate wisdom is now limiting us to only 1 month's rent. So hang on, ladies and gentlemen. And as I see, I don't see any other questions. So I'm going to end this right now. I do appreciate you guys coming out. I really enjoy doing this myself. And I will have this, oh, do I have a hand? Oh, I got one. Well, no, I don't think so. This is that 1217 again. So I do really appreciate you guys coming out and participating in this. Tell your friends, because I really want to raise this up. I do see one more, 3726, last one. Hopefully it's not a zinger. I'm going to ask you to unmute yourself by hitting *6.
Okay. Okay, it's Suzette again. Just based on what you just said, I have a duplex, so it's just me on one side and then I rent to a tenant. So I can charge the double security and the first, like, right? The first, the last, and the security.
Yes, you can. You can certainly do that.
Okay.
Everybody,
Okay.
thank you so much, and have a great day and a great holiday. Appreciate everybody.
You too.
Bye-bye.